As it pertains to special and general murder, two overt acts in jurisdiction, this court will deny the defendant's motion. All right, Mr. Menendez, number 3, overt acts and insufficient specificity of vague terms.
Yes, Judge. This is a just special demurrer as to several parts of the indictment. I'm referring again to part 3. The only overt acts that Mr. Farley's alleged to be in out of the 191, that's number 95, 103, 110, 120, 132, and 141. Those are the ones I'm talking about here. Your Honor, here, the court's actually pretty clear. I mean, the Sarajewski case, held that that indictment was deficient and that it lacked any description of what was alleged to be threatening communication. So here in this motion, Your Honor, I'm shifting our focus to these vague terms that they're putting in the indictment that Mr. Farley is entitled to be more specific so that he can be prepared to defend himself at trial, because he is entitled to an indictment perfect in form within its four corners. And the key thing here, Your Honor, under Sarajewski is that it needs to be sufficient so that he can avail himself of a defense, to prepare himself for a defense. He's not given enough intelligence here about what he's even going to be fighting. So just like when Sarajewski dismissed that count for threatening communication or endeavor to impede, that's what I'm arguing here, Your Honor. There's also the Delaby case that didn't survive a special demurrer. That had the term intimidation being insufficiently specific. So, Your Honor, each of these overt acts, except for 173 and 176, do contain terms that are so vague that we can't possibly prepare our defense intelligently within the four corners of the indictment, Your Honor. And he can't be sufficiently apprised of what he's going to be prepared to meet at trial. 173 and 176, I do concede, okay, those are specific enough. It talks about shooting a person with a gun. That shooting with a gun, that can't be committed in any other kind of way. But importantly, Your Honor, the Delaby court holds that the term intimidation was impermissibly vague because intimidation can be committed in so many different ways. And again, Your Honor, despite its age, Ralston v. Cox is still good law. It's an example where the court has the authority to demur specific overt acts of conspiracies, not just whole conspiracy. And so, Your Honor, now I want to go to each of these acts and the allegations and how they're vague. So number 95, again, appearing in a video released on social media, doesn't say what that means. What do you mean appear in a video? And just the proof of what I'm saying, Your Honor, is the way it's been talked about at different points during this case in the proffers. Appear in a video, appearing doing what? Saying what? Rapping, dancing, what? It's just, that doesn't say like appear in a video, Your Honor. It doesn't say anything about how that's furthering the objectives of anything or what that even means, Your Honor. Same thing with number 103, that he appeared in a YouTube video titled Mob Ties and that the defendants were flashing gang signs with lyrics. He doesn't say, does he even say these lyrics? Does he mouth them? Did he write them? Does he rap them? What? It doesn't say, Your Honor. It just says he appeared in a YouTube video and then says defendants were flashing gang signs with lyrics. Which defendants? It should have said which ones. It should have said what they mean by appear. Should have said what they mean by the lyrics. What is the significance of the lyrics and Tupac and Hit 'Em Up? Doesn't say. Just says he appeared in there. Same thing with 110, Your Honor, a YouTube video of a song of Mr. Wunny Lee saying vaguely and sufficiently that he appeared in it. At first bond hearings, they tried to say like he was saying the lyrics or he had something to do with the lyrics. And while I don't think those lyrics are probative or have anything to do with reality, even so, he's not alleged to have written them, rapped them, mouthed them. I want to know, he needs to know what appear in a YouTube video means. And then they just say some lyrics. And Your Honor, now number 120, a photo released on social media that he posed for a photo. What does that mean, posed for a photo? How is that the overt act? What about posing in a photo and that it was released on social media? What is that? What is an overt act about releasing something on social media? Again, doesn't say anybody saw it and doesn't say what they mean by posed. So then go to 132, that he engaged in a conversation. this one really needs to be defined, Your Honor. Engage in a conversation, that's vague. What do you mean engage? Talking and talking back? Having your account that maybe you don't even manage get a message from other people that you don't respond to? Is that what they mean? That's what it is, but we need to look at it within the four corners, Your Honor. And so to say vaguely, oh, he engaged in a conversation, and then say stuff that they allege Mr. Williams to have said, what is that? How do I defend against that? What does that even mean? Same for 141, Your Honor. Posing for a photo. I already made those arguments for Act 110. So, Judge, those are the ones. They're all impermissibly vague. They each contain at least one vague term that needs to be further defined because it's not defined enough, just like in Delaby and just like in Severance, where those things were not sufficiently defined. Here, I would argue to the court, we have terms that are even more vague than the terms in those courts which didn't withstand a special demurrer. And I know the state's going to cite the case law that, oh, we just have to track the language of the statute, but that's only the first part. It's a two-part analysis. They have to track the language of the statute, but they still have to sufficiently appraise the defendant of what he's going to be defending himself from. And these vague terms rob us of the chance to do that, Your Honor. And so that's why those overt acts should be dismissed by a special demurrer because they are impermissibly vague.
All right, thank you, sir. All right, Mr. Floyd?
Yes, Your Honor.
First point is the state is not required to allege every overt act. The state is not required to allege overt acts in great detail. That's the law. They are not separate counts. They are overt acts as part of an overarching count. And so the level of specificity which Mr. Farley is seeking is simply not required. I can only say it strikes me as feigned confusion here. As to each of these acts, the state has alleged the specific date. It has alleged everybody who's involved. It's not like he doesn't know what we're talking about. Okay. The individuals in almost every one of these acts that are referenced, other than Mr. Farley, are co-defendants. The idea that he is bewildered at what it means to appear in a video, to appear in a photograph, is simply an untenable argument. What does it mean to be released? Well, people talk about releasing videos, releasing movies, releasing all kind of TV shows, et cetera, all the time. Social media, not exactly a vague term. And numerous times we've mentioned the specific platform like YouTube. A conversation, again, not real confusing, particularly since we've quoted language from the specific conversation. And he has the videos. He has the photos. He has the transcripts and recordings of the conversations. And so under the standards that we've cited before, including Sanders versus State, that is more than sufficient. We're not talking about something where Mr. Farley wasn't present, and we're not talking about something that Mr. Farley hasn't received in discovery. We're not talking about something that's some grand mystery about what's going on. I've never seen a case that said this is demurrable, and I don't think this is going to be the first one. If Your Honor has any questions, I'd be happy to address them.
No, I don't.
Very briefly about that, discovery has nothing to do with here. It's not feigned or not feigned. It's that you need to do the legal analysis and you need to put everything out of our mind except for the four corners of your head. Case law is very clear about that. So it doesn't matter that I've seen the videos. He's entitled to indictment perfect and form within its four corners to sufficiently appraise himself. So all that extra stuff is actually not part of the court's analysis. It needs to be restricted to the indictment itself only. We are going to feign ignorance because we pretend for purposes of the error that we don't know anything else except for the indictment. That's what it means.
Your Honor, Sanders versus State, unanimous decision, Georgia Supreme Court, 2022. The additional detail desired by Sanders may be supplemented by the pretrial discovery he receives any investigation or counsel conducts.
All right. I'm going to deny your motion in regards to general demur, special and general demurs 3, overt acts and insufficient specificity of vague terms. Let's move on to the issue involving unindicted co-conspirators, Mr. Menendez.
Okay, thank you, Judge. And the last three are actually very short and straightforward. I can probably do it all three.
That'd be fine. Okay. Unindicted co-conspirators, insufficient nexus, and distinguishment between overt and predicate acts.
Yes, Judge. Those are the same arguments under special demur that he's entitled to an indictment, perfect in form, that within its four corners puts him on notice of what he's going to defend himself against. The way that fails in this regard is that they just say in the indictment that Mr. Farley and the other co-defendants, together with unindicted co-conspirators, did these things. Well, for the indictment to be perfect in substance and form within its four corners, they need to say who those unindicted co-conspirators are. So that is the substance of this motion, Your Honor, merely that it doesn't withstand a special demur because it includes these unindicted co-conspirators without telling us anything about them or who they are. So that's that one. Number 5, Your Honor, it's just an insufficient nexus because under Schiffels v. Kemper Financial Services, which again, yeah, it's a civil case, but that's something unique about Rico is that it does have a civil component and a criminal one. And there's no difference in how those are decided. There's a difference at trial of what their burden is, either preponderance or beyond reasonable doubt. But as far as demurs, there is no difference. And there is a civil application of Rico. And in that application, Schiffels v. Kemper Financial Services, they say that to allege a conspiracy to violate Georgia Rico, the state would have to plead that each defendant knowingly agreed to conduct the affairs of a particular enterprise and that each conspirator agreed to the commission of the predicate acts and that each defendant knew that those predicate acts were part of a pattern of racketeering. So how can I do that when I don't know who these supposed unindicted co-conspirators are? So, Your Honor, again, under Schiffels, it says conclusory allegations of conspiracy are not sufficient to allege a criminal act under OCGA 16-4-14 and 16-14-8. Rather, the state must allege facts from which one can infer each defendant's agreement to violate the laws the state contends constitute the racketeering activity. So, Your Honor, for those reasons, it can't survive a special demur to have an indictment that says, oh, together with unindicted co-conspirators, because then how are you on notice of how to defend yourself? How are you on notice about what attorney you want to hire, whether you want to make a plea, when you don't know whether that specific intent is going to be satisfied? You don't know who these unindicted co-conspirators are. That's a pretty simple thing, Your Honor. I think that line, unindicted co-conspirators, either needs to be removed or needs to be re-indicted to tell us who those unindicted co-conspirators are. As far as insufficient nexus, Your Honor, that's the one I was just talking about before that the allegations need to allege facts to infer that each defendant's agreement to violate the laws. That was actually, I was talking about the nexus, Judge, my bad. There, they don't allege that, Your Honor. So the nexus between the enterprise and the conspiracy is insufficient by this indictment. And then lastly, Your Honor, they say overt and predicate acts, the part that I referred to in count 1, where they say that some of these, certain of which are acts of racketeering, that's again not acceptable under a special demur. They need to say which are the overt acts and which are the predicate acts. They can't just list them and then say certain of these are acts of racketeering. They need to say these are the acts of racketeering, these are the overt acts that aren't. Because otherwise, how do I know which one they mean is which? So those three, Judge, insufficient nexus, that applies to the entire count 1. But as far as the distinguishing between overt and predicate acts and unindicted co-conspirators, that's just something that also needs to be included, Your Honor.
All right, sir. Mr. Floyd?
Yes, Your Honor.
So we have unindicted co-conspirators, insufficient nexus, and distinguishment between overt and predicate acts.
Yes, sir.
Then we'll move on. I think there's, Mr. Menendez, you haven't dealt with duplicative counts.
Oh, Your Honor, I think that Mr. Floyd said a different colleague.
I'll handle that response, Your Honor.
Okay, all right, okay.
Okay.
All right.
So on number 4, Your Honor, unindicted co-conspirators, no case cited by Mr. Farley that says we're required to identify those and kind of misses the fact that they are unindicted. And there's a problem with identifying individuals who are unindicted in an indictment because they don't have the ability to come in and demur or otherwise seek relief. Their reputation can be devastated, but they don't have standing to come in and do that. That is why it presents, I can't say it never happens, but that is why the state and also the federal government are very reluctant to do that. And you see things like unindicted co-conspirator A or unindicted co-conspirator 1 referred to in indictments because that person doesn't have a chance to come in and respond. They're not a party. There are some jurisdictions that suggest it may be unethical to do so. That's not a universal rule, it's a practice, but it makes sense. Second, we've identified all unindicted co-conspirators who are known to us in discovery. We haven't held anything back on that. As far as insufficient nexus, the case is charged in the language of the statute, and it specifically references the nexus. And all nexus is a connection. There has to be some kind of relationship. Kimbrough is the controlling case on this, unanimous Georgia Supreme Court case written by Justice Peterson. And it basically says it doesn't take much and gives a number of examples. We have specifically alleged they conspired to associate together and with others for the common purposes of illegally obtaining money and property through a pattern of racketeering activity and conducting and participating in the enterprise through a pattern of racketeering activity. That's exactly what a nexus is. And that is more than sufficient under Kimbrough. We then go on to give specific examples of what was done, such as preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, including murder, assault, and threats of violence. That money, weapons, and other property were obtained through acts of racketeering activity, including robbery, theft, and the unlawful sale and distribution of drugs. We also allege that persons who were involved in the conspiracy to participate in and conduct the enterprise obstructed law enforcement investigations and court proceedings through witness intimidation and attacks upon law enforcement officers. That's drawing the connection between the conduct and the enterprise. That is all that is required. Distinguishing between overt acts and predicate acts, we did. I mean, we did exactly what Mr. Farley claims we didn't do, and it's right in the indictment. It's a key dramatic moment when the screen went dead black on me just as I picked it up. Your Honor, I'll just start with Act 1, and I'll blessedly stop with Act 1 because there's 191 of them. But in that case, we talk about aggravated assault with a deadly weapon, a firearm against the person of Reginald Pettis. Go through the allegation. In violation of Georgia law pursuant to 16-521, which is an act of racketeering activity under OCGA 16-4-3 sub 5A little v, and an overt act in furtherance of the conspiracy. Where it is both, we say exactly that. We do it over 70 times. Where it is only an overt act, we do not make the reference to the underlying incorporating provision from Rico. An example of that is number 7, which involves Mr. Murphy. We consistently did that throughout the indictment. That's exactly what he's complaining of. The thing he says is missing is there.
Okay.
That's all I have right now, Your Honor.
All right, sir. In terms of,
Can I tag along to the first part of that one, the unindicted co-conspirators, not the other ones, but I do have a similarly situated motion with regard to the identity of unindicted co-conspirators. And the indictment does say the defendant conspired to associate together and with others. Doesn't say who the others are. And we can argue this at a separate time. I have no problem with that, but I do want to say, in contradiction to what Mr. Floyd said, that we routinely file motions for the names and identities of unindicted co-conspirators. They may not be put in the indictment, but we routinely are provided with a list of unindicted co-conspirators because we all are entitled to know who we have conspired with, number one, and whose statements may or may not be able to be used against us under 801D2E. So I just want to tag in on that one.
All right, thank you, sir. All right, based upon the arguments and applicable case law, I'm going to deny defendants unindicted, amended special and general demurs for unindicted co-conspirators. I'm going to deny insufficient nexus, that's general demurs, special demurs 5. I'm going to deny distinguishment between overt and predicate acts. And I think that gets us to the duplicative counts in terms of general and special demurs, as well as the motion to sever counts, motion to sever the trial of defendant, motion to declare the Georgia gang statute and corresponding rule of evidence 418 unconstitutional, and the Georgia Rico statute unconstitutional.
And Your Honor, I was wondering, I know we're getting late into the day. I'm going to be here all day, all week. So if the court would like to.
2 shows daily.
Here's the one I'm doing tomorrow, and just hear Mr. Floyd's. That's as amenable to me or the court.
Okay, Mr. Floyd, what else are you arguing, sir?
I've got severance and constitutionality, Your Honor.
All right, let's go ahead and roll those up at this point in time, and then I can, is that the only other two, Ms. Rosenwasser will handle the rest?
I believe I think it's those, and then I'm handling the one about the duplicative. And
Yes.
I'm sure I can.
We'll push that till tomorrow along with the other ones related as it relates to you. But just so we handle the ones involving Mr. Floyd this evening. So, sir, if you could go ahead and continue with that.
Okay. Well, I think Mr. Menendez may want to make his argument first.
All right.
Yes, I'm prepared to respond to both.
So you're going to do the motion to sever.
Man, at the end of the day, man, all of this shit is just gibberish and small talk, like holding up the court. Like, if you ever look at that shit, man, I'm trying to understand wordplay and all of that, and sometimes that shit is just gibberish.
Okay, that's fine. That's fine. Okay, all right. Okay, Mr. Menendez, go ahead, sir.
Yes, thank you, Judge. As far as severing counts, what I'm asking here, Your Honor, for Mr. Farley is to sever his trial into count 1, the Rico count, and then another trial that has the other counts that he's alleged to be in, which is 49, 50, 51, and 54. So, Your Honor, Johnson states that pretty clearly that when 2 or more crimes of the same or general nature are committed against different persons at different times and places, and they're charged in separate counts of an indictment, severance is mandatory upon the defendant's motion if the crimes are joined solely because of their same or similar character. Your Honor, that's Johnson v. State, 364 Georgia Ave. 543. That's from 2022. It goes on to say that if the offenses are not joined solely because they're the same or similar character, and evidence of one charged offense would be admissible as a similar transaction during trial on another charged offense, the trial court's vested with discretion in deciding whether to grant the motion to sever. So there's nothing commanding Your Honor to do it one way or the other. But I am asking Your Honor to do that because the court does go on to say in that case that in making this decision, the court must consider the number of offenses, the complexity of the charges, that's crucial, and the complexity of the evidence, and determine whether a jury will be able to fairly and intelligently parse the evidence and apply the law. So here, Your Honor, we have a completely unfair trial as it counts to the murder counts Because here what we have, if you were tried just on the murder counts, we have a person who's an entrepreneur, networking, and finds himself riding in the backseat of a car that's behind another car, and then something happens where we don't know the circumstances. So, Your Honor, that's a very different kind of trial than me having to fight that on its own versus me having to fight that now with all these people and all these attorneys and all this evidence of Rico going back to 2013, 2015, wiretaps, all this stuff, just to simply decide whether sitting in the backseat of a car makes you a party to a murder when there's no other assistance alleged and he's merely present, merely associated. And so, Your Honor, to get up here and then you're going to tell the jury, oh, mere association doesn't count on these counts, but then here's a whole Rico case where the entire nature of the case is association, which is okay. I mean, I disagree with Rico, as we'll find out from our other motion, but to do a Rico count and then these murder counts together is just, not fair, Your Honor. And they are joined solely because they're the same and similar character. So that's that, Your Honor. I mean, there is nothing. There's the murder of Mr. Schmeldrinks, and then the jury's analysis of the burden of proof on that is going to be just completely confused by the complexity of the other case. And then it really is just this presence and this association that ties him into the Rico. So under Johnson, Your Honor, I'm just asking this court to sever count 1 from the rest of the counts just for Mr. Farley.
All right. Go ahead and argue the rest of the, that's the motion to sever counts. What about the trial? And then you can deal with the gang statute, your argument on the gang statute and the Rico statute.
Yes, Judge. So admittedly, this motion to sever the trials is a lot stronger. And I do think it's less discretionary and leads, if we don't sever it, to a situation where Mr. Farley's rights are just completely trashed. So, for example, the biggest reason, Your Honor, is because there's so much evidence admitted against one co-defendant that wouldn't be admitted against him. Okay, but what I think is the strongest argument, Your Honor, is just the scale of this. We've had all these pretrial hearings about how it's going to take 6 to 9 months. And so, Your Honor, to have a defendant like Mr. Farley, who doesn't have the resources like some of the other defendants, who we now see still don't have an attorney, Your Honor. So I think the proof is right behind me how difficult it is for someone to hire an attorney of their choosing, free of conflict, which is his right under the Sixth Amendment. He has a right under the Sixth Amendment to an attorney of his choosing, free of conflict. Had it not been for me agreeing to do the case, that would be impossible. And that's impossible for a lot of the co-defendants, Your Honor. We've seen that. When you try 28 people at once, you're like taking up all the private attorneys of the city that you live in, and you're asking that private attorney who has had to go through years of training, hundreds of thousands of dollars of education, and now these clients essentially rent us out for their advocacy. And that's just not fair, Your Honor. It's like, oh, you're going to go to the prom, we're going to rent you a limo, but now, oh, actually, this prom is going to last 6 to 9 months, and you're going to have to rent a limo every single day. You're going to have to rent out Mr. Menendez to sit there with you every day and pay him by the hour. That's not fair. It's not fair, Judge. So that will be solved by severing the trial of Mr. Farley. That might be fair to some other defendants who are all over the discovery, but Mr. Farley, he's only in like 7 out of the 191 overt acts, and he's only in 4 of the counts. So in that 6 to 9 months, my actual engagement in his advocacy will be a matter of days. It's something we can do in a week and a half. But what the state has done to rob him of his rights under the Sixth Amendment and his rights to due process and his right to be treated equally and not be discriminated against based on wealth or anything else, they've put 28 people together. And then for those people that are in such a small part of the discovery, they've created a situation where you don't get to pick your attorney. You just get to hope that you'll have someone agree to something, even though it might not make sense. And now look what we have. We have people who are still unable to hire an attorney. And I think part of it is because of this lack of severance. And so, Judge, to force Mr. Farley to sit there with a paid advocate who's not going to do anything for months at a time is not fair, Your Honor. They're essentially picking his attorney for him by saying, oh, you got to have this amount of money or otherwise you can't defend yourself, which is not fair because what he only needs is someone to defend him for a few weeks. And this Rico count, they could easily just prove just those overt acts and the existence of a conspiracy. It's not going to take a long time. They're going to say, oh, they're going to make us redo this Rico conspiracy over and over and over. No, they just got to show what they say is a seemingly based on the rulings of my other motions. It's not that hard. A nexus, a few overt acts, a pattern, and that's it. That can be done with just a handful of witnesses in addition to his other counts, Judge, but that should be separate. That way it can be done in like a week, week and a half. And that way Mr. Farley isn't forced to defend himself in the way that he has to resort to because of money and because of this sort of wealth discrimination of accusing this many people at once of something, Your Honor. And so I included other arguments, of course, but those have been articulated by other co-defendants in the past. It's more just for the record. But I do cite some things like Morris v. State, whenever it appears necessary to determine a fair determination of the guilt or innocence of a defendant. To have a fair determination of that, Your Honor, Mr. Farley should have his trial severed so that it can be just a week, week and a half, and then he can have an attorney of his choosing, free of conflict, and he can have his due process and his confrontation under the Fifth and the Sixth Amendments.
Okay, let's move on to now the, your argument in terms of the gang statute, unconstitutionality, as well as the Rico statute.
Yes,
Which one do you want, Your Honor? Concentrate.
Um,
I'm doing Rico, Ms. Rosenwasser is doing gang.
Okay, let's see then. I will table Ms. Rosenwasser's one till tomorrow. She's doing the gang statute? Madam, is that what you're doing? Okay, all right.
I'm sorry to interrupt.
That's okay. No, that's fine, sir. Okay, then you're doing unconstitutionality Rico.
Yes, sir.
All right, handle that for me, please.
Oh.
Let's do that tonight.
Yes, Judge. Things don't change until they get challenged. Our country has a long history of case law that then realizes, oh, this was wrong. And it just takes someone doing the right thing and challenging that for that determination to even go up to a higher court, Your Honor. So that's why I am objecting to these. Your Honor, just because something has been deemed constitutional in the past just doesn't mean that it is. And I think
What's
this
your
case
basis?
specifically.
What's your basis to have,
Yeah.
for me as a trial judge in this case,
Yeah.
to have it declared or the unconstitutional? Hasn't our Supreme Court already passed on this issue?
Not as it pertains to this exact set of facts. That's why this is distinguishable, Judge. One, the scope of it and the financial aspect, but also the First Amendment aspect. We have several overt acts here that involve artistry, just entrepreneurship, clothing, and that's an unconstitutional application of finding someone accountable criminally for something.
Well, I think the
we'll get
state's
into that.
argument is when those acts, and this is what I guess we'll find out at trial, whether or not those acts are basically admissions. So
Exactly, Your Honor.
So, that's something we'll take up at trial.
Yes, Judge. And I of course, I don't expect the court to rule in my favor on this, but I do want to have it for the record. And you never know, this is a chance to do something cool. And I think it is the right thing, Your Honor. The vagueness as well of the Rico
So
statute.
you have to have a good faith basis to challenge the statute. So I think you've raised one. If you're saying that is the issue of the interplay between the First Amendment and clothing, some other things. Yes, that is fine.
Yeah.
And you certainly are well within your rights, and you wouldn't be a good advocate if you weren't doing that on behalf of your client. Okay.
Yes, Judge. And just real quick for the record, the other things I put in my motion were the fact that they're able to put so much evidence in the indictment itself is unconstitutional. We don't get to do that for any other allegation. There's social media pictures in the indictment. Your Honor is going to read the indictment to the jury, and they're going to see actual evidence before they even get to the opening statements. That's not how it's supposed to work, Your Honor.
So I'm going to read it,
that's
but actually I'm going to tape it. So, and I don't plan on showing them the picture. So.
Yes, Judge. And then lastly, we don't have any mechanism here like we do in civil law to have a motion for summary judgment, which is a type of thing I think would have been granted for Mr. Farley here, because not only is the indictment doesn't allege anything, the discovery itself and the warrant affidavit itself for his arrest simply alleges presence and association. So there's nothing stopping the state when they're out to get somebody, they can just in bad faith with a warrant that doesn't say anything about how you're a party, just loop you into a big RICO case and then start pressuring you to cooperate or take some kind of deal, because what else are you going to do? But there is no mechanism pre-trial to have your honor look at any of that. And so that's another
motion
aspect.
suppress.
Well, I can't suppress the whole case, Judge. I can only
I know,
suppress.
but as it pertains to your client, you filed some 23 motions. I think you're doing a fine job.
Well, thank you, Judge.
Okay. Anything else? Relates to
I ain't gonna lie, I agree with that judge. He was doing a fine job up there, yo, for real.
Officer tomorrow cover the duplicative count issue as well as the gang statute. And I think she said Mr. Carlson will come in and argue the evidence 418 issue. Okay?
Yes.
Yes, sir. Ms. Johnson.
Response, we just like to join in Mr. Menendez's motions with regards to the severance of the count and the trial.
That's fine. Okay. All right. And Mr. Floyd,
Yes, sir.
whatever the ruling is, can I ask you to prepare an order on whatever grounds on the issues that I've denied? You prepare suitable
1
order?
through 6, the amended special general. Yes, sir.
All right,
Will do.
let me rule on these things first, and then I'll let you. I may, depending how I rule on these, I may ask you to include these. Okay.
Whatever the court's pleasure is.
Okay.
Yes.
All right, sir.
So severance. Your Honor has already heard severance motions, I believe 7 of them.
I have.
You have already denied them all.
Yes.
I had a feeling you'd remember, but just in case, I wanted to remind you. The mistaken premise, and it's been true throughout them all and is true here, is the idea that somehow if you sever, the trial becomes much smaller, shorter, easier, a week or whatever. Unfortunately, it doesn't work that way. This is a conspiracy case. We're going to have to prove the enterprise. We're going to have to prove the overt acts, and the evidence is largely the same. I can't say it's exactly the same. I won't go that far, but it will be substantially the same in each circumstance. And so there's not that time efficiency that keeps getting rolled out in front of you, simply doesn't exist. That's the primary reason why, and we've cited these cases previously, I haven't been able to find a reported Georgia RICO case where severance was granted and the issue came up on appeal. I just haven't seen it. Every one of them, the posture is severance has been denied. The court looks at it, the appellate court looks at it, says it's a matter of discretion, and discretion was appropriately exercised. And those cases are very similar to this one. We've also cited to you on the same principle an extensive number of federal RICO conspiracy cases. I'm dealing specifically with RICO conspiracy because the question is the same and the standard is essentially the same. The problems that we've mentioned in the past, inefficiency, the trauma of causing individuals to testify repeatedly to violent acts they've suffered, the opportunities for witnesses to shape their testimony in subsequent trials, all of those considerations, that's not the entire list, but we've briefed it extensively in the past. They don't go away. They would actually only get worse if Mr. Farley was to have 2 trials, one on RICO and one on murder, et cetera. That doesn't solve the problem. It really magnifies it. I think part of Mr. Farley's constitutional arguments drifted over into the severance side, or perhaps he feels they're applicable to both. It doesn't make any difference here because he was talking about Sixth Amendment issues. Mr. Farley has an attorney, and that's Mr. Menendez. Mr. Menendez has, as you pointed out, filed a very extensive list of motions on his behalf and is fighting for him as hard as he possibly can, as we would all expect him to do. So, but part of what comes with that is Mr. Farley doesn't have standing to raise constitutional issues relating to other people who don't have counsel for whatever reason. He can raise his own. He could raise it if he didn't have counsel, couldn't obtain it, but that's not the situation. And therefore, that's just not an argument that's available to him. As far as constitutionality is concerned, let me first address vagueness. There are quite literally hundreds of RICO challenges based on vagueness. None have succeeded. There are hundreds in the federal system. There's approximately a half dozen, I believe, in our system. And the counterpart state RICO statutes across the country, there's about another 35 or 36 of them. Many of those have been challenged. Vagueness has not worked once. Vagueness didn't work in the Rodriguez case against our gang statute either, for essentially the same reasons, because the statutes have a lot of similarities. There's nothing new here presented on vagueness that hasn't been addressed in the past. In fact, there's nothing really specific at all presented on vagueness. As to First Amendment, it just conflates the problem. The argument that keeps, or the state presented, is that speech has been criminalized. That's not what we're talking about. We are talking about speech as evidence. There's no offense that says somebody's not being charged with making an offensive lyric or video. That crime doesn't exist in Georgia. It is not alleged in this indictment. But the fact that somebody is engaged in some sort of performance doesn't immunize them and doesn't create a First Amendment shield against all responsibility. I've not been able to find a case that said that a charge is unconstitutional or a statute is unconstitutional because some sort of performance is involved. And frankly, that wouldn't be a basis to hold the statute unconstitutional. It would be a basis to exclude a specific piece of evidence. I imagine that's an argument we're going to get to pretty soon, but that's not a constitutional argument here. The United States Supreme Court in Wisconsin versus Mitchell made it absolutely clear that something doesn't stop being evidence because it's in a book or a movie or a poem or a song or a diary. Because that would lead us to the absurd circumstance in which a person who simply picked up the phone and called the police and said, I murdered John Smith. I did it in this place. I did it on this day. I did it for this reason. And I did it using this weapon. You can go find his body right now. Well, we pretty much know what's going to happen there, right? But if I post it on YouTube and I sing it, that becomes inadmissible. And if we use it to charge, the statute becomes unconstitutional. There's nothing, absolutely nothing that supports that. The too much evidence in the indictment, this is exactly what I was alluding to before, which is the argument that the sort of Goldilocks argument the state usually faces. It's either too much or it's too little. It's never just right. But, you know, this is the same defendant who 30 minutes ago was arguing that we hadn't given the dictionary definition of various phrases in it and now says, but wait, this statute's unconstitutional because you can talk about too much. Those two things can't occupy the same place at the same time. As I said, I am not aware of any case anywhere in the country holding any RICO statute unconstitutional on any of these grounds. Don't think this should be the first one.
Okay. All right. As it pertains to the amended motion to sever counts, I'm going to deny that motion as it relates to Mr. Farley. I'm also going to deny the motion to sever his trial from the other co-defendants. And I'm also going to deny the motion to declare the Georgia RICO statute unconstitutional. So, Mr. Menendez, we will take up there's three things I think we'll take up tomorrow as it relates to Mr. Farley's duplicative counts and the unconstitutionality of the 418 and the and the gang statute tomorrow. So I'll take up those. I've otherwise, the other issues, as I've indicated, we'll table those until such time as, like, for the autopsy photographs and the music video and social media evidence, okay?
Yes, Judge. The evidentiary motions for 28.
You got three, yeah, we will take up those on the 28th. Yes.
Yeah. Yes, Your Honor, our witnesses would be available on the 28th, so.
Yeah, but those are only the three, for those three motions, right?
Yes, Your Honor.
Okay, all right. So we'll take up those then. All right. In the waning hours of the day, let me just recap, Ms. Rosenwasser, for tomorrow. You've got Walter Pineda.
Yes, Your Honor, he'll be coming first.
You got Quentin Hall.
Yes, Your Honor.
Okay, do you have anybody else that potentially you might be able to move up, or might be depending upon how we go tomorrow?
Not to my knowledge, I'll reach out to Investigator Worrell tonight. He was one of the people on for Wednesday. I can see if he's available. But we do have Mr. Stillwell's motion to dismiss. We should be able to do that. I know the court wished to hear that tomorrow as well.
Okay, all right.
And then obviously I'll be ready for Mr. Farley's motions also. The two that we just talked about.
All right, I think that's plenty. And then there'll be some, I'm sure that, folks, just to put you on notice, Thursday, we will have to take up the issues involving the jury questionnaire. So what I'd like you to do is prepare for we have a list of the questions that we propose to ask. What I'm asking you all to do is, if you have a specific objection to a question that the court is going to put in the questionnaire, you come prepared to argue those on Thursday morning. I'm not going to go through all of them unless I absolutely have to in that respect. But you've had plenty of time at this point in time to kind of consider that. So Thursday morning, we'll take up that issue. Is there anything else I need to kind of, as an administrative announcement, I need to do? Mr. Floyd, you'll take care of a suitable order. Send that to Mr. Menendez.
I will do that. And, Your Honor, I just want to ask one question to the format. There were 6 amended special and general demurrals, and they were filed each as a separate